Good morning, Your Honor. Petitioner raises this morning the Civil Rights Act of 1866, codified at 42 U.S.C. Section 1981, which confers to all citizens, rather all persons, a right to equal protection, and specifically describing the right to sue and present evidence as their civil rights. The primary issues in this matter now before this court, as well as raised in a collateral challenge presented to the federal courts. At most direct issue this morning, Your Honor, is an injunction that the petitioner has averred is unlawful, and which most immediately presents an obstacle to his constitutional right to file a notice of appeal without retaining an attorney, or in the alternative, upon a grant of leave of court, a procedure, although apparently not an issue of first impression, as exemplified by the precedent cited by the Commonwealth attorney, which says not even a prescribed form for those who, to the satisfaction of the court, have presented a sufficient history in this instance of just two cases alleged to be similar that have been filed without a legal cause of action, imposing an onerous and unbearable burden and expense to opposing parties in the courts, all to which the petitioner respectfully but strenuously takes exception. Genesis of this matter arises from a provision in the Virginia Code, specifically VA Code Section 19.2-217, which confers to a competent witness the right to present, upon sworn affidavit, evidence to a Commonwealth attorney for the purposes, in the case of a misdemeanor, to prosecute on information, or in the case of a felony, to convene a grand jury, which is consistent with the statutory scheme describing the duties and responsibilities of a Commonwealth attorney, a constitutional officer, as codified at VA Code Section 15.2-1627B, which expressly confers a discretionary authority with respect to misdemeanors, but which uses mandatory language in describing conduct characterized as felonies, to which, in objection, the Commonwealth attorney has denied, arguing that the plain language of this statutory provision confers rather an absolute and plenary prosecution or prosecutorial discretion, going to the extent in argument to claim that no lawful authority in the land could compel him to investigate or prosecute even any felony, presenting the hypothetical to wit that even if there was probable cause that the mayor had committed acts of murder and terror, no lawful authority in the land could compel him to do anything about that. To the extent, as apparently the Commonwealth attorney is convinced that a disease that in two bookend trace contact studies, one even completed by the WHO in China at the beginning of the global health crisis, and the other the largest ever conducted on the first variant of the novel coronavirus, published in November 2020, has been found to possess a secondary attack rate of less than 5%, about the chances of any one of the approximately 60,000 applicants to Harvard University receiving an acceptance letter for admission. Petitioner has presented to the federal court a request for declaratory relief to confirm or deny that such a probability would conform to the characteristics of a highly contagious disease, which at least scientific reports before involving science would have affirmed that such a metric was 12 times too low to be described as a highly contagious disease capable of setting off a super spreader event. And to the extent that only one of 96 students in the class of 2022 in the second best public schools in the state of Virginia had been accepted to Harvard, the Supreme Court has said in U.S. Gibson, a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. To the extent that the Commonwealth attorney is convinced that the case filed by petitioner in Chesterfield, which he concedes to be similar in nature to the one presently before this court, is frivolous and unsubstantiated, petitioner has submitted a question to the local bar association for verification in rejection of findings and conclusions by the Circuit Court in Chesterfield and State Supreme Court, to which that case have been certified to the Chief Justice to appoint a retired jurist to reside over that matter, at no time finding the case to be frivolous or vexatious. Petitioner has also requested of the local bar association to confer with him, work with him to develop a form for future matters in being proactive, so that others similarly situated will be able to obtain leave of court to file at least an appeal, if not present other cases with a form that they will be able to understand and present with clarity to a court to obtain their redress and in recognition of their rights to use the court. And to the extent that the mandamus procedure, which had even been recognized in a decision by Chief Justice John Marshall and Marbury Madison, is no longer recognized as a substantiated legal cause of action, petitioner at a minimum request leave of this court to present a notice of appeal of constitutional right to present that issue an assignment of error to the state Supreme Court to review that decision. Nothing further, y'all.
What have you got in the end? Nothing's the answer, my friend.
This message was approved by Major Mike Webb. Honest.